And okay, I think I am going to get this started. Thank you to everyone who is tuned in to be with us this afternoon. And an early happy Thanksgiving from the gang here at Fire. My name is Peter Bonilla. I am Vice President of Programs at the Foundation for Individual Rights in Education. And most of what I do these days has a lot to do with our faculty programming and development, including the production of these webinars, which have been very important to us, especially this fall, as like a lot of organizations, we haven't been able to do the same kind of in-person programming that we usually would be doing. And judging by the number of people we had sign up for this afternoon's webinar, I think this is a simple matter that there has been a lot of interest in, and our panelists this afternoon can definitely go into a lot more detail about that. Joining us today is Adam Steinbaugh, an attorney and the director of Fire's Individual Rights Defense Program. He oversees the team at Fire that investigates and carries out Fire's defense work for students and faculty at institutions around the country. And 2020 has been a remarkably busy year for that crew. It's something that I have a significant degree of sympathy with, because among my various duties at Fire in the 12 years that I've been here has been running this same program, doing our case investigation and management. But I definitely never saw it quite the way Adam Steinbaugh has seen it this year. He's done a phenomenal job with his team leading our defense campaigns. We're very happy to have him here to talk about his process, talk about what faculty can do to better defend and their rights on campus and be better prepared for investigations or potential violations of their rights as they come. A couple of quick words off the top I will give before handing it over to Adam. Firstly, nothing that we discuss on this webinar in terms of the hypotheticals that we might go into about various legal matters should be taken as legal advice that is being given by Fire. Second, if you have questions about a particular case or a particular ongoing matter that you may be dealing with, probably the best way to address those is to email either Adam or myself. You can reach Adam at adam@thefire.org or me, peter@thefire.org. And we will happily discuss the matter with you from there. Lastly, actually, there may be no lastly. That may have been everything that I wanted to go into there. With that being said, Adam, I'm very happy to hand it over to you, and thanks very much for joining us this afternoon.
Thanks, Peter. As Peter said, my name is Adam Steinbach. I'm an attorney here at Fire. I'm an attorney, which means that I make poor life choices, and you should probably log off now. I head Fire's Individual Rights Defense Program, also known as IRDP, and it is one of two teams that work in tandem to defend faculty members' rights on campus and within the United States here at Fire. What we do, just to give you kind of a general lay of the land, is there are a number of ways that the rights of students and faculty can be infringed. One of them is through the maintenance of a policy that has not yet been applied to anyone. That is the province of our Policy Reform Department. IRDP primarily handles situations in which a policy has actually been applied to a particular identifiable person or an organization or a student or a student newspaper, so on and so forth. There are probably 4 different tools that we have at our disposal for us to be able to help people whose rights are threatened. The first one are our investigative tools. This is somewhat of a new approach that we've taken at Fire, is the use of public records requests. When I first got to Fire, I don't think that we had ever issued a public records request, and now I think we conservatively send 300 or 400 a year. And what that allows us to do is to see what administrators at institutions are saying behind the scenes so that we can evaluate their public positions and their assertions and determine whether or not they are credible. One example, and this is probably my favorite case that we ever had at Fire, was a professor at, or I think she was an adjunct at Essex Community College in New Jersey. She was invited to appear on Tucker Carlson's program because she was sort of a talking head, or she wanted to become a talking head, someone who speaks often on television. And she was asked to defend a Black Lives Matter event in Brooklyn or New York City that was excluding white people from the event. It was not an event that was taking place at a university. She didn't mention her affiliation with the college during her appearance, but the appearance went somewhat viral because she was combative in the appearance. She mocked Tucker Carlson and she defended the Black Lives Matter event. Very quickly, she was suspended and then subsequently fired by the college. And the college's president put together a video explaining that the college had been inundated with complaints from the public after this appearance. And because of that, because they were inundated with complaints, they had to let her go. Well, we issued a public records request and then sued the college after they ignored those. And it turned out that lo and behold, the college that was inundated with complaints had one complaint that had been sent to them by the time that she was suspended. And it was some member of the public who had pieced together that she was at the college. The investigative tools help us determine whether or not administrators' claims are credible, and they aren't always. The second tool that we have at our disposal is the power of persuasion. That means that we are writing to institutions to persuade them to change their practices and to correct a violation of rights. This typically comes in the form of a letter laying out the facts as we understand them, inviting the institution to explain their side of the facts, and explaining why, if our understanding is correct, the institution has violated a faculty member's rights. The second tool that we have is the power of publicity, because we believe that what an institution does in private, they probably can't defend in public if they're not willing to defend it in private. So why go public? One, it helps you defend your own rights because it puts the institution on the record and requires a public response, or at least a response that we could make public. Two, it helps defend others' rights because when you stand up for your own rights, it advances the rights of everyone. Three, it informs the public about their own rights. So a lot of the First Amendment and expressive rights generally, people broadly understand what that means, but the application is somewhat nuanced. And the more that we can reach people to explain what that means in practice, the better. Four, it encourages others to speak out about violations to their own rights, because there's always safety in numbers when you're standing up for rights. So we have a couple of different ways that we can make something public. One, we can issue a press release or a blog describing the situation and laying out why we think the institution is in default of expressive rights. Two, we can speak to the media and explain to journalists and reporters why we think the institution is violating rights. And three, we can play matchmaker with journalists, meaning we help pitch the story to a journalist who is going to be able to tell that story better than we might be able to. That being said, going public is not always the right option. Not everyone is in a position where they can publicly defend their own rights. And we often find ourselves helping people privately. So if somebody contacts us and does not want to go public with their case, we will not make that public. Finally, the fourth tool at our disposal is the power of litigation. So if the court of public opinion is not going to give us a solution, the court of law might. I should warn that our litigation mission is very narrow. We are not always able to consider a case for litigation. And just because we are taking a particular case and helping to articulate rights does not mean that we're going to be able to litigate something ourselves. So with that being said, I kind of want to broadly talk about the concept of academic freedom and free speech generally. I view these as somewhat interchangeable concepts. I think the best way to approach it is to view academic freedom as the application of freedom of expression in the context of the university, which means that the institutional interests or the ability of an institution to regulate or penalize speech is limited to its cognizable interests or its legitimate interests. So I think there are two big questions that we approach in a particular case that both consider sort of the same topic. That is where the speech occurred. First, is it at a public or private institution? This makes a difference because the law and the theories that apply are somewhat different at public and private institutions. The First Amendment is a constraint on government, and if you are at a private institution, that means that the First Amendment is not going to limit what the institution can do. Institutions are free to form their own relationships with people. That is something that the First Amendment protects, and some institutions, some relationships are not going to guarantee or promise any sort of expressive rights. But most private institutions still say to their faculty members, to their students, to the public, to their accreditors, and to the federal government that they do promise freedom of expression. Because I think that is, that's at the heart of education, or at the enterprise of the university, and I think it's what most people expect. So at a private institution, you can rely on, or you should be able to rely on, the promises that they've made, and there are certain aspects of federal law that may come into play depending on those promises. So although it's not a private institution, UCLA recently had an investigation, or a purported investigation, into a lecturer who was reading from Martin Luther King Jr.'s letter from a Birmingham jail. And in that letter, MLK repeats some of the racial slurs that had been directed, I believe, at him and his family. And this lecturer repeated those. Students got upset and complained about it on Twitter, and UCLA referred that question to or for potential investigation. The Department of Education sent a letter to UCLA opening an investigation, arguing that because the university makes promises of academic freedom, by initiating an investigation into the lecturer, they had departed from those promises. That is a theory that applies not only to public institutions, but to private institutions as well. So turning then to public institutions, you can rely on not only the promises and that federal protection, but you also have constitutional rights. So although you are, if you are a faculty member at a public institution, although you are an employee of the institution, you still retain a First Amendment right to speak as a private citizen on a matter of public concern. At that point, the analysis becomes sort of a balancing test, which means that the inquiry is whether or not the needs of the institution outweigh the interests of the faculty member to speak as a private citizen. That is a high burden, but it is very fact intensive. So the second question that we look at is whether or not it was in class or outside of class. That's sort of a trick question because what we're really looking at is whether or not it's academic speech or extramural speech. Extramural speech is speech that occurs outside of the academic environment, broadly speaking. So where we see this most often is on social media, where a faculty member on their own personal account tweets their views about politics or what have you, and other people become angry about that and want the university to take some action into it. Um, a gray area where this gets a little bit harder to define is when it involves other constituents on campus. So there was a case several years back at the University of Nebraska at Lincoln where a graduate student who I believe she was also a lecturer had learned that someone was tabling for Turning Point USA on campus, and the graduate student was aggrieved by TPUSA because of the professor watch list that the organization runs, and she wanted to respond to that. So she whipped up a couple of signs with some other faculty members and stood around that table protesting the TPUSA table. During that exchange, she flipped off the person who was running that table. It turned out that the person running the table was an undergraduate student at the institution. And the University of Nebraska at Lincoln ultimately took action against the graduate student. We felt that that was wrong. We thought that was extramural speech. And although it is uncivil, flipping someone off is protected speech. So why is it important to protect extramural speech? Well, as a faculty member, you're not only a faculty member, but you're also a citizen. And people who are, people should not be, or should not lose their employment for having the wrong views as citizens. Because if you can remove someone, or if you can determine who can teach based on their extramural views or their personal views, then you can control what's said inside the classroom as well. The main approach, well, there are two different approaches that we have for addressing instances of censorship based on extramural speech. One of them is the concepts around contract and the promises that institutions make. So, for example, at Marquette University in Wisconsin, there was a faculty member who was aggrieved by graduate students teaching in class and criticized her by name on his personal blog. And other members of the faculty and the university believed that this was, again, uncivil, that he was essentially harassing the graduate student by calling her out on his personal blog, and they took action against him. The Wisconsin Supreme Court said that that was unlawful, finding that the extramural speech that the professor had engaged in was protected by virtue of contract. Because the university had adopted the AAUP's 1940 statement on academic freedom, the court said that the university had essentially contractually waived the right to punish a faculty member for extramural speech. So that's one theory, is the theory of contract. So that would apply at both public and private institutions. The second approach, only at a public institution, is the First Amendment. So again, you would have a right as a private citizen to speak as on a matter of public concern. Now, this is probably not going to be as broad a protection as the contractual right to academic freedom, in that theoretically, because the First Amendment right is limited to matters of public concern, it's questionable whether or not that would encompass certain types of institutional criticism and certain interpersonal disputes. I think that academic freedom is more likely to protect institutional criticism, but interpersonal disputes are harder to argue as being protected by either the First Amendment or academic freedom. Beyond that, when it comes to academic speech, so in other words, if you have two different categories of, or two different modes of analysis, there's academic speech and there's extramural speech. Turning to academic speech, this can consist of speech in class or syllabi. It could consist of academic research or publishing, so on and so forth. But this is limited to a certain extent, at least in class. The speech has to be pedagogically relevant. So you can have a minor detour in class, and even if it involves material that others might view as inappropriate or offensive, so long as it's a minor detour, you're probably going to be okay. But if it's pedagogically relevant, it's much easier to argue that it's protected by notions of academic freedom. This is distinguishable from continuously or persistently introducing controversial or inappropriate matter. For example, there was a lecturer in Arizona who was, I believe, a creative writing lecturer, and he spent a good deal of his class time playing videos relating to the QAnon conspiracy theory. That was probably not protected because the material itself was not apparently related to the class itself. So that is something that a university could probably regulate without offending notions of academic freedom, because it doesn't matter what you're showing, it matters that it's irrelevant. So if something is pedagogically relevant, it's a lot easier to articulate a defense explaining that, you know, although people inside the class or outside the class might be offended by it or think that it is inappropriate or wrong, the point of having academics and having professors is to be able to interrogate and explain and discuss controversial matters, even if others find them offensive. So why is this important? Well, it's because faculty members are experts. They're hired to articulate and explain matters within their expertise. And that means that it is their judgment, not the administrator outside the classroom, or worse, the politician, who gets to decide what they teach or how they teach it. So again, there are two different approaches here. There's the contract or academic freedom argument, which is fairly straightforward. And then there's the First Amendment. The First Amendment question is tough here sometimes, depending on how developed the law is and which jurisdiction you are in. And that's because if you are speaking as an employee, there is a Supreme Court case called Garcetti, which creates a problem. Garcetti essentially held that if you are an employee of an institution, the government gets to regulate what you are saying as an employee, as opposed to what you're saying as a private citizen outside of class. So if you are a faculty member and you've been hired to speak inside of a class or through research or through writing, that could be seen as government speech. Now, a dissent to the Garcetti case pointed out that this is problematic for faculty members and for the notion of academic freedom, because it would mean that institutions would be essentially given pretty wide discretion to punish faculty members without offending the First Amendment. And since then, a number of courts have held that there is an exception for academic freedom to Garcetti. So this is still a developing area of law, and we think that there is an exception to Garcetti here, but it's still developing. So as Peter mentioned at the outset, this has been, I feel kind of foolish, because when institutions started shutting down in the spring and sending people home, I started turning to our staff members and saying, okay, we should probably start looking for longer term projects that we can spend our time on, because nobody's going to be on campus, classes are canceled, and you know, we're just going to see our cases trickle up, and you know, we're not going to have much speech to defend because nobody's talking. Well, it turns out that sending everyone home and putting them online and giving them a lot less to do means that there's a lot of people who are angry. There are a lot of people who don't have much to do other than complain. And there's a lot more speech to complain about. Our cases have seen about a 50% increase over the previous year, which was already much higher than normal. So far this year, we've sent about twice as many letters as we did last year. So we still got plenty on the barbecue to keep going or keep pushing with. So we've seen a significant number of cases as of late, and again, that's partially because of the civil unrest, and partially, I think, because of name recognition. I think that as we have more public cases and more people know about their rights, they tend to recognize more violations of their rights, and because we are involved in many of these cases, more people know about FIRE and come to us. So I think there's two different things at issue there. One is that there's probably more cases, and then some of it is that there are more people who know about us and come to us for help. We've seen, I want to talk about I guess, two different types of cases that we've seen.
Adam, would it be okay for me to jump in for just a real quick second? I remembered the thing that just because I'm starting to see some questions coming in, and I'm realizing that what I forgot to say at the outset. If you came with questions that you'd like us to try and answer, please feel free to put them into the question and answer field. It's open for anyone who wants to add them. With the number of people that we have joining us today, we probably won't be able to get to all of them. In which case, I encourage you to email either Adam or myself, and I'll follow up after this webinar with everyone to make sure that you have our information. If you have questions, please feel free to start loading them up now. We'll do our best to answer as many as we can. And Adam, that was what I wanted to say. So please continue on.
Yeah, and I would also add that if you have a question that relates to a particular case that you're involved with, the best thing to do would be to contact us using the website. The URL is super easy to remember. It's thefire.org/alarm, haha. But that's the best way to contact us because it'll give us more time to evaluate your situation and figure out whether or not we can help, and it helps maintain some privacy. This summer, I think, or in this year, we've broadly seen a number of different things that seem to happen over and over and over again. One of them is that there's been increasing, or we've seen more cases in which administrators are taking action over the presentation and interrogation of offensive material and in particular racial slurs. One example was the instructor at UCLA who was reading from Martin Luther King Jr. We also saw, I believe last year, a librarian who was at Doane University, who, as people were confronting the issue of yearbooks and other historical documents showing that blackface had been fairly predominant or common at their institutions in the past, a Doane librarian had created an exhibit that showed some of the photos that were taken from the Doane library's archives of their own yearbooks, and she had been penalized for that. There's a case out of the Sixth Circuit in which an instructor was asking students at a community college about different types of offensive speech, and he solicited the students to share examples of offensive speech. In doing so, a number of students used obviously pretty offensive words, including racial slurs, which the professor or the lecturer repeated. The Sixth Circuit held that because these were pedagogically relevant, they were protected by the First Amendment. So faculty members have a right, a First Amendment right, at least at public institutions, to discuss and to confront offensive materials, including racial slurs, in ways that others might find objectionable. Again, that's the decision. How to do that is the decision of the faculty member in the classroom, not the administrator outside of it. The second issue that we've seen quite a bit of are, and this is probably not news to anyone, but pressure from students and faculty, or on students and faculty, over their social media commentary. We see this quite often from people on the left when the commentary is about race, sex, or gender, and that occasionally leads to student or public pressure on the institution. But we also see it quite a bit from the right when it is commentary on political issues, and sometimes commentary on race, sex, or gender. And there we tend to see pressure more from political actors and conservative media, in addition to members of the public. Our focus is on the institutions, because the institution should be responding to this criticism by explaining and articulating the First Amendment and academic freedom interests at issue. That is why they exist. And it is an opportunity to inform the public about what that means in practice. And too often it is the institutions that actually fail to defend their faculty members' rights. So that is where our focus is. So in terms of, if you need to contact, or if you think that your rights may have been infringed and you want to contact FIRE, I would say first, or if you want to defend your rights generally, I'd say first, you should know your rights and be informed of them before you dean us, because if you're able to better understand how those rights work in practice, you're going to be better able to identify when they're infringed. This is particularly helpful at private institutions where the analysis may turn on the letter of your contracts or the policies, whereas at public institutions, it's easier to rely on broad First Amendment values, which may be more uniform than some of the policies at institutions. Two, relatedly, if there is a chapter of the AAUP at your institution, I always recommend that faculty members get in touch with the AAUP. They are consistent and strong advocates of academic freedom and freedom of expression. And having a union, whether it's affiliated with the AAUP or not, at your institution is going to be a very good tool for defending your rights, particularly because it means that there's going to be, or it's more likely that there will be someone who can help you articulate your rights within the contracts and relationships that exist at that institution. So if you do think that your rights are infringed, it's better to get in touch with us early, because it's better for us to say, no, there's no threat here that we can help with, rather than for you to get in touch with us when it's too late for us to be effective, because we're not going to be able to be effective in every case. I would also suggest that if you can, get in touch with us before you decide to go public, because again, one of the tools that we have is the power of publicity. But if you go public, that makes it harder for us to find the best time to go public and to gather the evidence or materials that may help you put the best foot forward in going public. Of course, that's not always an option. When there are controversies, they're often public anyway, but not every controversy is public. So again, if you find yourself in trouble, the best way to contact us is through our website, thefire.org/alarm. And yeah, I think now we can turn it over to questions.
Yeah, and I will, and everyone, thank you very much. I see them coming in over the last few minutes, so I will do my do my best to get to each one of them and to get a good variety of questions that we're able to offer some thoughts on. I'll start with this one, which is a good thought experiment. That's actually one we do at Fire quite a lot. I'll paraphrase the question. In contrast to the creative writing course in the Arizona example, an instructor that shows videos regarding anti-maskers or political rally attendees or other conspiracy theories regarding vaccinations in a healthcare ethics course, would that be acceptable as a kind of pedagogical or academic freedom issue?
I think so. I think it's within the ballpark at least. It's enough for us to play with in that sort of situation. I'd particularly want to see, the syllabus or the course material or something else that we can help or we can use to help articulate why it's pedagogically relevant. And one of the difficult things about our job is that it requires us to very quickly learn a lot about particular subjects if we are going to be able to help articulate why things are relevant. Fortunately, we get to depend on the faculty members who come to us for help because they are best at being able to articulate why it is relevant. I think in that situation, it would probably be relevant so long as there's some explanation as to why there was that discussion. It's not as if you are in, I don't know, a calculus class discussing political rally attendees at length or something like that. Although who knows? Maybe there's a way to articulate how that would be relevant there. I certainly can't do math. That's why I became a lawyer.
I would just add to what Adam said, as the person who's been in the position also of reviewing quite a lot of things in that general orbit, maybe not having to do with anti-maskers or conspiracy theorists or whatever. I would just add to Adam something he already said, which is that yes, each case of this type is very fact specific. We want, there's all kinds of things that we want to know about the circumstances in which something like this might surface in a class. Definitely based on the question as put to us. There is, I'd say there is a presumption that there could be some pedagogical relevance to it, but again, we'd want to see, if possible, the syllabus of the course. If possible, get as much sense of the character of the exchange or the context that it was presented in, because that's another kind of tricky thing about cases over in-class discussions, is that it's frequently very difficult to have a perfectly reliable record of what might be discussed. You're often going on secondhand accounts or conflicting statements about what was said, what wasn't said. But yes, based on that question, I definitely would agree with Adam that we would, it at least bears the presumption of a possible academic relevance. So we would have to, we would want to see what might come along to disconfirm that impression. So thank you for that. Next question, this is probably something again Adam and I could both offer some thoughts on. But we've talked about the AAUP a little bit already, and we have a question: what are the main differences between FIRE and a group like the AAUP with reference to faculty protections? Adam, do you want to take a shot at that?
Sure. I think that we depend a lot on the AAUP. Their guides, their commentary is very informative. It helps inform our thinking, and sometimes we will approach something and or approach a particular case, and the AAUP will come out on a different end of it, or come to a different conclusion. And maybe that sometimes changes our minds and changes the way we look at it. The AUP has been around for a very long time. I think that when they weigh in on threats to expressive rights, I think that institutions would do well to pay attention to them. And one of the things that they do very well, and I wish I'd love to come up with a way to help model this, or come up with a similar approach, is when they, and I'm forgetting the phrasing of it, but when they impose sanctions on an institution that has ignored their advocacy and violated expressive rights, they will insist on keeping those institutions on a list of institutions that have violated rights, and they will do so for some time. And that means that if an institution isn't going to provide redress to a violation of rights now, it means that at some point, in order to get off that list, they do have to take some sort of action to fix the wrongs that they've undertaken. I think that is an effective strategy, and one that helps advance the rights of faculty members everywhere. So while we probably might have some philosophical differences at the margins, or about how we sometimes analyze or approach expressive rights, whenever someone comes to us and has a difficult case, I always encourage them to also reach out to the AUP, because I think having more voices, especially credible voices, weigh in is going to help defend the rights of the individual faculty member. So that's a long way of saying that I like the AUP a lot. I consider them to be effective advocates in this sphere, and they are one of the first groups that I recommend to people. Peter, I don't know if you have anything to add on to that.
All I would add, I mean, now Adam, you've done a very good job with that, and I agree. Is that as Adam said, the AUP has been around a long time, more than 100 years, and what that, an upshot of that is that their policy statements have, in a lot of ways, kind of set the ground rules for modern American academic freedom. And a lot of their policies, especially in my days in IRDP, when I ran the program, when I was investigating faculty cases, I kept a copy of the AAUP's Red Book policy manual by my side. I cited it frequently. I think in particular, like a great service that has been done is the AAUP's 1940 Statement of Principles on Academic Freedom and Tenure, which is not only a very valuable statement in itself. It has become kind of so widely adopted, and it has so significantly influenced the academic freedom policies at other institutions that it has kind of taken on almost a kind of common law status. It has a lot of it pulls a lot of moral weight even at institutions where it might not be technically in effect. So there's also that aspect of it. In my own work, I've relied significantly on its reports, on its policy statements for guidance. Okay, I've gotten what I wished for in terms of inviting questions. Let me just see. Question: Have you encountered any cases where faculty have been denied professional development reimbursements for attending FIRE conferences, or encountered any issues with tenure promotion because of affiliations with FIRE? In my knowledge, no. If that ever did happen, I would hope that you would give us a call or send us an email very promptly. To my knowledge, fortunately, the answer to that, as best I can tell, is no. If they are out there, I certainly would hope that we would hear about it. Adam, is there anything more you have to to add to that?
I can't think of any instances like that.
Okay. We've gotten a number of questions around around this various topic, and it's a bit of a thorny one. I'm gonna read out one and take it as kind of representative of the number of questions we've gotten on this. And the question is, can a public university require all of the syllabi to incorporate diversity into the subject matter? Can adhering to a particular diversity viewpoint be used for faculty evaluations for tenure and promotion? I know this is something that we have been getting more questions about. This general kind of constellation of issues. Adam, is this something that that you've been seeing more of at IRDP? Is it something that that you have some preliminary thoughts on, perhaps?
Yeah, we've seen more and more of this, especially over the summer. It is still something that we are trying to figure out how to approach because there are a couple different things going on here. One of the things that we see often are the question of diversity trainings, meaning you have to attend some sort of course or seminar or online video, so on and so forth. In general, the institution can require people to attend those sorts of trainings, but there are certain limitations to that ability. So, for example, if they're requiring someone to attend a training because that person said something that was protected speech, the requirement that they attend the training might be retaliatory and might be something that is inappropriate. Relatedly, there could be situations where an institution imposes a training in response to a particular instance of protected speech in a way that makes it appear that faculty members are being broadly punished, or that people are being punished or being required to attend trainings in a way that is going to make it less likely that someone will engage in protected speech because they don't want their colleagues to have to go through another training. So those are situations when a training might be inappropriate just because you're being required to attend it. There are also situations where a training might be inappropriate because it requires someone to express a view that they do not hold. Now, that's different than being required to attend a training about what the institution's policies are, or being required to answer what the or to explain what the institution's policies are in response to one of these trainings. It's different if you are being required to state that you agree with a particular view taken by the institution. That is something that may be problematic. So yeah, there may be situations where the training itself is inappropriate, but most of the questions that we get about trainings are turn on whether or not you can be required to attend them at all. Generally, yes, they can require that. There are also questions about whether or not changes in syllabi or similar initiatives, particularly surrounding tenure or promotion, and taking into account the contributions to diversity in that process. Those may raise questions about whether or not those requiring such statements from faculty members imposes a litmus test. But what we are looking for are situations where those statements have been required as part of the promotion or tenure process or annual review process, and we can show that an adverse decision was made based on those criteria. So We are monitoring those. We are interested in hearing more about those, and we are particularly interested in hearing from people who have been impacted by those. I don't know if that answers the question.
Oh, I definitely, definitely, I am glad for your last bit, Adam, which is to say that, and I'm in this same boat too, is that we're very curious to know more about the specifics of these kinds of things, these requirements, for whether they're syllabi statements, whether they're new trainings, new programs. It's something that we hear a lot about, and there is a lot of speculation about, and some trepidation about, but something that as of yet, I think it remains mostly to be seen what kind of form they might take. If they're still things that are being developed at universities. It's not the kind of of initiative that's going to be taken care of quickly in a lot of cases. In terms of developing these kinds of things, are probably ongoing throughout the academic year or the semester. Like, I feel like in this job we always have to say the specifics of each one matter, and it's a very fact intensive process, but unfortunately the specifics matter, and it's a very fact intensive process. But like Adam said, we are very interested in hearing more about the specifics of these kinds of developments as they may impact faculty. So and I see that I think we have gotten a couple kind of more specific examples that have come through in the questions, and we'd very much like to talk more about those. So please feel free to email either Adam or myself, and we're happy to talk about it further. Okay, another question, and this is actually something that we have seen to some extent. So I'm happy to take this one. What does FIRE currently see going on with the use of Zoom backgrounds during faculty meetings or course session meetings for online classes? Adam, I believe we've had a case or two of this stripe. So can you talk a little bit about how our process has worked there?
Yeah, this is a kind of a fun one, because I turned to one of my colleagues right at the outset of all of this that I was expecting two types of cases to eventually come down that were going to be kind of new once the pandemic started. One of them was the question of what happens when someone puts on a mask that has something offensive drawn or written on it. And then two, what happens when a student comes into a Zoom class and has an offensive background. We've seen a number of these cases so far, and it kind of recalls the Tinker v. Des Moines case, which is the seminal student free speech case. And the analysis is going to be different between students and faculty, but we can analogize to Tinker in that what was happening in Tinker was that students wore black armbands to protest the Vietnam War. And at the time, that was a really offensive thing to be doing, especially in Iowa, where fellow students or recent graduates could have already been sent off to Vietnam and killed, and people viewed this as a very un-American thing to be doing. And students wore black armbands in classes, and the Supreme Court essentially said, "Look, that's so long as you are not taking action, or you're not imposing broader limits on speech," meaning an institution could limit having any sort of expression at all in the class, but they couldn't discriminate between types of expression, because all the students were doing was wearing something passively in class. They weren't disrupting the class. And the mere fact that other people could see this expression in class and could theoretically be distracted by it was not enough to overcome the students' First Amendment rights. I think if you are a high school student, or if this applied to students in middle and high school, then it certainly applies to college students. And there's not a whole lot of difference between wearing an armband passively in class and having something in the background of your Zoom meeting in a class. And that's especially true because I think that you can block people on Zoom or hide them on Zoom and ignore them. Maybe it's different if it's animated or it is something that is going to be such that you just can't ignore it and it is distracting. But I think that's a pretty high barrier to cross. Now, applied to faculty, it's probably going to be different because again, what you have in your Zoom background is probably not going to be speech on a matter of public concern. And it's going to be harder to make an academic freedom argument if it has nothing to do with what you were teaching. But still, I think that's one of those situations that we'd want to take a close look at it and see if there's a way to make the argument. Because I also don't know that the institution's interests are significantly compelling to justify punishing someone for having a background. Hope that answers the question.
Yeah, we had a question come in asking if, and I think you sort of got to it, Adam, about the potential Garcetti aspects of this for faculty. To my understanding, I think it's true, Adam. Although I'm not in all your meetings, who knows what you guys see? But most of these, more of these cases have happened in the kind of student context, with the Tinker context that Adam discussed, and it, apart from the the one or two cases we've had on this, I've seen a number of other cases of this over the summer and fall in the high school context, where Tinker still where Tinker still reigns, but a number of other lousy Supreme Court First Amendment cases are claw back some of that territory and make it a little bit more complicated from a First Amendment point of view. Well, one thing I might add is we've had a number of cases over the years. This is not quite apples to apples, but we've had a number of cases over the years that have revolved around how faculty decorations, wall hangings in faculty offices, pictures in their offices, things hanging on their doors, and to an extent, how the sort of the First Amendment right if you're at a public university, or the kind of general free speech, academic freedom-ish right to sort of maintain the independence of your own space. I think there's something to be said for that, and and depending, maybe that can factor into some of these. But at the end, I'll defer to Adam's best judgment on that. Adam, do we have time for maybe like 2 or 3 more questions? We've still got a few coming in, and
I think so.
We started a couple minutes after 4, so we can go to a few minutes after 5 and try to get to a few more of these. Let me see. I will very quickly answer this from a friend, from one of my friends on the call. Do you have videos about fire available that people can share with their institutions, for example, their AAUP chapters? Surely, yes. I'm happy to follow up with you. More specifically, we churn out an ever increasing amount of video content, probably to an extent I myself am only dimly aware of. One upshot of doing these webinars is these are things that we record and we post these on our website and our YouTube page. So because we want to make them useful to our faculty peers and allies for as long as we can. So this recording, in the next few days, we'll have this posted to our website and you'll be able to share it around. But I'm happy to talk more about that and give more ideas. I'm sure there's so much great video content that would suit the bill there that I probably am not even aware of. Okay, let me see. I sure that'll teach me to be so solicitous of questions from the attendees because it's 5:01 and we've still got a lot of good ones sitting here. I'll take maybe a flyer on this because I'm not sure how well defined this is. Early question we had come in: how do legal guarantees of academic freedom apply to professional associations in the various disciplines? Adam, do you have thoughts there in terms of for one, any the extent to which there may be any case law on that? I'm really not sure, or otherwise.
I think it depends on what you mean by professional association. So, if you have a league of extraordinary astronomers or something, which is an organization for, or a private organization for astronomers, they have their own First Amendment right of association to define for themselves what commitments they have to academic freedom. So if they promise academic freedom to their members, then I think a member would be quite right in insisting on adhering to those. If they say that we are only going to accept members who accept Pluto as a planet, then that is their own right as well, even if that would be a decision or a requirement of membership that may be at odds of notions of academic freedom, because I think people could probably come to different conclusions about whether or not Pluto is a planet. That is their own right to use, even if it is not necessarily a wise exercise of that right. That doesn't mean that they are immune from criticism for doing so. And I think that even if they do not make a promise of academic freedom, you could make the argument that they should make an argument to academic freedom, or that their hesitation to allow such members is going to have a deleterious effect on academic freedom. But generally, professional associations are going to be associations that are free to define their own membership and to take their own positions and stances and so on and so forth. I think that is distinguishable from the institution itself, but just add another qualifier to that: to the extent that the institution defers any of its authority to a private association, then that delegation of authority may have some, or will probably carry the obligations of academic freedom. I don't know how that would play out necessarily in academia or in terms of faculty associations, but we see this most commonly with student governments, in that often public universities or private universities will extend to the student government the ability to grant recognition or funding to student organizations. So although the student government may often be a private organization or entity, because they're exercising the authority of the institution, they still have to adhere to the promises of academic freedom or freedom of expression or the constitutional obligations.
Yeah, to what Adam kind of got to it with his last part of that, but yeah, one thing that's one thing that might color the analysis, and this is something that we see. This is something we see in a lot of professional training programs, in programs that require certification by a certain board, where graduates of certain programs, have to, meet certain dispositions or certain professionalism or certain ethics standards that are set by an external board, but which are kind of which are enforced internally by what might be a public university, and it gives and it can give these organizations a kind of gatekeeping function, with the power potentially to keep people out of certain professions entirely, for speech that is sometimes on the basis of speech that is totally protected by the First Amendment. We've seen this in a number of programs. So that might sort of get at the question in a little bit of a different way. Adam was making a glare, and I hope I wasn't stepping out into really dangerous territory with my answer there. I don't believe I was, but it is something.
I just took off my glasses, so I'm squinting now.
Okay. Thank you. As always, Adam, he's the lawyer here. So listen to him, even though he says, I'm a lawyer. Don't listen to anything I say because of the choice I made. I'm going to go to one last one, and because I think it's a good one to end on. We've had a couple to this effect, and I know it's something that I've gotten inquiries on over the year. I'm going to kind of paraphrase it here. But the question is, in the current environment, there are many issues where it is difficult, and there's a lot of pressure against taking certain unpopular stances on particular programming or particular policies, and there is worry, that you might be the subject of of a kind of pressure campaign, whether you might be kind of stormed on social media, your email might be flooded. We've seen it happen any number of times, and we've been contacted by a number of faculty who are in the midst of those kinds of campaigns. In terms of what we might be able to advise them, how we advise faculty in those circumstances, what resources we have, and what we might recommend in terms of kind of steeling yourself for the potential onslaught. Adam, is there particular wisdom you've offered faculty who are in that kind of situation?
I think that you can't really know until you try. I think that a lot of trepidation and fear that people feel about the possibility of something happening to them. It is, while there are some pretty egregious instances of people encountering either pushback or harassment or retaliation for their speech, it is still, maybe a little bit optimistic, but I still think it's unlikely that most speech is likely to lead to the level of pushback or retaliation that is likely to jeopardize a career or your safety or anything like that. So that's a long way of saying that I think that you don't know that something bad is going to happen until you try to speak. I think that we have very robust protections for freedom of speech in this country, and we're here to try to assist in defending those rights. But it's you don't know until something happens, and I don't think that being too cautious about the possibility that something will happen is a good thing. I don't think that is the chilling effect that results from that is something to be avoided, and the only way to avoid it is through speaking, because otherwise it doesn't really matter whether or not someone is going to retaliate against you or harass you or push back against you, because your silence has already accomplished what they would try to accomplish. If something happens, get in touch. But until then, the conversations, the difficult conversations that happen on campus or off campus or in politics or outside of it depend on people being willing to voice their own views and to be ready for other people to disagree. I think that is the very purpose of the First Amendment and freedom of expression is to engage in disagreement. So.
Thank you, Adam. Very good answer. I'll only add to that, and then we'll wind down this discussion. One thing that I am working on in my work is a kind of structural program thing, because we have at this point had a lot of conversations with faculty members who have either been through this kind of scenario or are kind of confronted with it as it is unfolding. And one thing that I am trying to do is be able to connect our members with others who have had kind of similar experiences, who can share their own thoughts, so that the collective expertise and collective wisdom of the faculty networks members can be used to serve their peers. That's one thing that I'm working on. That's one kind of long-term change that I'm undertaking in terms of being able to really let this be a place where people don't just have to come to us, where there's a way that hopefully we can kind of take ourselves out of the role of the middleman, and our network members can be able to better connect with each other, and sort of share notes, share their experiences, and advise each other based on what they've been through and what they have found works and doesn't work. Well, everyone, thank you very much. I'm sorry the hour the hour and a little bit of bonus time has flown by, but I'm very glad that we were able to have this discussion. I thank all of our attendees for the excellent questions. Again, and you'll see one of the answered questions. I gave my and Adam's email, so feel free to email us with any more questions that you have. I know we weren't able to get to anything. I know some people have specific things they're looking to discuss, and we're happy to try and help that out. So thank you to all our attendees for listening, for the excellent questions you brought. And thanks to Adam, not just for joining us this afternoon, but for the phenomenal job he has done running this program in a really unprecedented year in terms of the demands for FIRE's time. Like I said, I've been in his position, but I have not been in his position while so many things have been going on around it at once. He's done a remarkable job leading the department. So a big thank you from me to Adam for that. And again, thanks everyone for coming. A happy Thanksgiving from us at FIRE. Please stay safe. And again, the recording of this will make it available in the next few days. And you should all, hopefully in the next couple of days as well, get a follow-up email from me with links to a couple extra resources. So everyone, again, thanks so much for tuning in, and we look forward to doing the next one with you.
Take care.